Hearing the appeal, Emlyn Quashie against Ricarda Solomon.
Before you start, Mr. Barrow,
yes,
can I just make sure that Mr. Manwa can hear us clearly?
Yes, my lord, I can hear clearly.
That's fine. Good, thank you very much.
Very well. Lord, I appear on behalf of the appellant in this matter with Miss Sian McGibbon. Mr. Anthony Manwa appears for the respondent from Trinidad, who I'm happy to say makes his first appearance before the board in this appeal.
Could you speak? I don't know if the... Mr. Manwa, did you hear that?
Yeah. Have you got my computer?
Yeah, yes, my lord, I heard that.
You can hear Mr. Harrell. That's fine. You looked as if you were not picking it up. Thank you.
My lord, we adopt and... Forgive me.
You don't mind. Sorry, Patrick, we've got confusions here.
Yeah, sorry. I think we've sat in the wrong place.
The wrong computers. Bear with me.
Don't worry.
We're going to swap computers.
Lord Emlyn, can I just pass that across?
Okay, it's yours.
Yes, thank you very much.
Yeah.
Thank you.
Very well. My lord, we adopt and pray in aid our printed case and make our oral submissions before the board. It's split into 4 topics, which I'd like to give the board, but ultimately it really comes down to the 4th topic, I think, in this appeal. The first topic, A, is the powers of the registrar. B, the limitation period. C, estoppel. And D, the constructive trust. Now, my lord, the way this case began in the courts below, I think the board is aware that Mr. Solomon died before judgment was delivered in the court below. So Miss Emlyn Quashie, his partner, was appointed administratrix to continue this appeal. She has lived in the property for over 20 years, and the board will note from the SFI, and I just give you the paragraph reference, it's at E-bundle 496, paragraph 13, and I think that's also key bundle A, if anyone is using the key bundles, that following Beresford's death, the respondent forced entry to the property and to eject Miss Quashie. Miss Quashie regained entry and she remains in the property as at the date of this appeal. What we say, my lord, is that the consequence of the order of the court below is that Miss Quashie loses her home because the property would have to be sold, that being the agreed position by the parties at trial. And the respondent gets money representing half the value of the property, the remainder to vest in Beresford's estate. So the order made below matters greatly. Dealing first with the powers of the registrar, the first topic, we say that this is a simple matter of statutory interpretation. The relevant statute is at the bundle at 523, and this is section 24 of the Supreme Court of Judicature Act. And I don't think that this is at all controversial. It's a section that enables the High Court to execute a conveyance if a person who may have been ordered to do so does not. It's not an unfamiliar provision. However, that, we say, is the extent of the power, and anything the registrar does in accordance with any order made under this section must flow from the order that the court actually made. And the order is worth looking at, my lord, because it really is the beginning and end of how we say this appeal should be viewed. This is at E-Bundle 238, and it's in the Key Bundle tab B.
So you're telling us that section 24 explains why the registrar has been named in relation to the consent order?
Yes,
that's where
that's where that comes from. So that's the jurisdiction. The court makes an order and says the registrar is empowered, and that's pursuant to section 24. The order, which is at 238, is very clear in its terms. In essence, Beresford Solomon was to convey to Ricarda Solomon a half share in the property, and thereafter Ricarda was to become trustee for that half share for the respondent, who was at that time a minor. But what we say cannot be disputed is that the combined effect of the order we've just looked at and section 24 does not permit conveyance of the property direct to the respondent.
Was this argument taken at first instance or in the Court of Appeal?
Both. The original declaration sought, my lord, was for the deed to be declared null, void, and of no effect.
Well, that was the declaration sought.
Yes.
But what was this argument that
Yes.
Section 24 did not allow this? Because it doesn't seem to appear in the first instance judge's judgment.
No, absolutely. That's right. But the point was taken. Just bear with me a moment, my lord.
Can we show evidence of that?
Yes. I think it's in our printed case. Just bear with me.
Well, more materially, where is it in the statement of claim?
Well, can I first find it in the... I had this marked up, and here's my post-it has fallen out. Just bear with me for a moment. John... Got it? No, don't worry. Sorry? Well, I'm assisted by Mr. McGibbon. It was raised in the Court of Appeal. This is at
R24.
page 309, paragraph 24 of our case. But it was also raised in the trial court. And to deal with my Lord Stephen's point, my understanding...
Sorry, I didn't get those references. Could you just repeat them?
This is at
509.
309.
509, isn't it?
Paragraph 24 of our case.
309.
Yes. Court of Appeal.
509.
It's 509. It's paragraph 24 of your case.
Sorry, I'm actually giving my Lord two references. It's 509, which is in the electronic bundle, and the reference in the Court of Appeal would be at 309 in the bundle. So one reference in our case and then cross-reference to the judgment of the Court of Appeal. In relation to my Lord Stephen's question, if I can deal with that straight away, the declaration that was sought in the statement of claim was predicated on the basis that that was not a power that the registrar had. And ordinarily, it wouldn't be necessary to plead law in a statement of claim. It's foreign law. But that was the basis upon which the claim was made to say she did not have the power to do that.
I've read the statement of claim.
Yes.
The amended statement of claim. It doesn't assert that this was a conveyance to the wrong person. so far as I can see, anyway.
We'll double check it, my lord, but certainly that was an argument that was made.
Page 15.
And we certainly made that argument in the Court of Appeal on the basis that what had actually been ordered was not in fact what was permitted. Sorry, what was done by the registrar was not what was permitted. We say, in any event, that neither of the courts below fully appreciated or dealt with this issue, because if they had, then they would have accepted that as a matter of law, Section 24 did not empower the registrar to make a direct transfer to the respondent based on the order that she had. And there are additional concerns. I touch on it very generally, that if one is dealing with land and conveyancing, there is a degree of scrutiny that is required if you're going to be following a court order, but what you're being asked to do is not in fact what the court order says you are entitled to do. And we say that that scrutiny was absent here because we don't know exactly how, there's no evidence of it as to how the registrar actually made the decision, what was said to her at the time. All we know is that she made an order transferring the property direct to the respondent. I can find no case from Trinidad and Tobago where an order has been effected in this way.
As a matter of trust law, the respondent was the sole beneficiary, was of full age of sound mind, and she could have directed her trustee to transfer the property.
Well, that would be, we agree that if there was an action that could be taken, the respondent could have pursued her trustee, but on any view of the law or the facts, that wouldn't have been Beresford Solomon. It would potentially have been Ricarda or her estate, but it couldn't have been Beresford, and we can't find any authority that would support that a beneficiary, A, B, let's call her C, could circumvent seeking a remedy against her own trustee B and go to A. The most that might be said in dealing with the trust point, and we are going to address the board on it, is that if there was a trust relationship in which Beresford was involved, it was in relation to Ricarda. So Ricarda could have made, is that all right? Yeah. Ricarda could potentially have made an application as against Beresford, but there is nothing we can find that would have enabled the beneficiary under a trust constituted with Ricarda as trustee that would enable her not to pursue her.
2 stages, in effect, it's been short-circuited,
Yes.
hasn't it? You would have the setting up of the trust by the transfer to Ricarda.
Yes.
You've got no objection to that.
That would be consistent with
this argument.
Yeah.
And then the beneficiary under that trust would be immediately able to effectively call for the property to be transferred to her as now a full beneficiary.
Attaining majority.
A full age. So all the registrar has done is to short-circuit two aspects, has she not?
It could be described as a short circuit, my lord. I'm not going to quibble with the language, but it is not what the order permitted. And if the registrar was empowered to do that, and we're going to take the board to Mountney a little later, which is an authority we say is potentially helpful here. One of the things that would have to have been considered surely was when you're being asked to make that transfer. Now, if it's being done straight away, within 21 days, within 6 months, parties alive and so forth, there's no difficulty. But after 20 years, should a registrar short-circuit to make that order?
Colliding two separate points. You're saying if it was done a short time after the making of the consent order, you would see no real objection to short-circuiting.
Well, no. I'm not saying that. I'm saying that the transfer would have been from Beresford to Ricarda. I'm accepting that if that were to have happened, there's no issue. All legal and beneficial interests would crystallise. But that is not what happened here. And in terms of how to...
what happened here? I mean, I don't know whether we have no information in the judgments about who was the executor of Ricarda's estate, whether they were involved in this request made to the registrar. We just don't know. All we know is that the registrar presumably looked at the order and at the 1988 order and made the conveyance.
Well, what I would say, my lady, is we don't know. We don't know what information the registrar had at the time. We do have in the bundle the documentation for the will and the executor, so we know who that person was, but we don't know whether the registrar had any of that material. We just don't know, is the short answer. We've no idea what or how the registrar came to make this order. All we know, and it may be worth looking at, if you look at the deed, which is the 2011 deed, which is at page 34, what we do know from the documentation, and this was exhibited, this is at page 34, top right-hand corner, is that the deed was prepared by the respondent's attorney. And this was the deed that was then subsequently executed by the registrar. And you see her signature on page 36. But even if the registrar felt a conveyance other than that specified in the order could be made, we would say that it's not a matter of short-circuiting, that it did require a variation of the order with specific judicial oversight, because that is the only way, generally speaking, and we can find no exception to this, an order can be varied and then put into effect in a different way, because it has to follow the terms of the order.
But I don't quite follow this. You're saying, prima facie on this argument, no objection to a deed of conveyance to Ricarda.
Yes, there wouldn't have been any issue with that. But
what would then have happened is you have a constituted trust for the benefit of a person who is now of full age, and she immediately collapses that trust under Saunders and Vautier and takes the property.
If the conveyance...
All the registrar is doing is, on the face of it, quite rationally, bringing about what would inevitably have happened anyway.
Except that, my lord, the long delay, with no information as to what has happened in the interim.
Well,
and so...
That, I keep on saying in a sense, that seems to me a separate point.
It is a separate point.
A conceptual point that the deed is invalid because it goes beyond what the order allows. And I'm putting to you that effectively what the registrar has done is to take a pragmatic view on the face of it. We don't exactly know what's gone on, but on the face of it, a pragmatic view that says, well, I'm perfectly entitled to transfer the property to Ricarda. That will then be a bare trust for the benefit of Ayana, and collapsing that produces the result that the transfer goes to Ayana.
If my lord is inviting me to accept that transfer to Ricarda would have constituted the trust, I accept that. I agree. If my lord is asking me whether, in those circumstances, had Ayana been of the right age, she could have collapsed it and taken possession, I agree. What I'm saying, my lord, is that in the circumstances of this case, when one is dealing with land, dealing with property, there are very specific considerations that the registrar should take into account, and the only one here were the terms of the order. And even though a view could be taken that, oh, it's pragmatic, I'll just transfer it to Ayana, the registrar can't do that unless they have a power to do it. And if we're right about that, then pragmatism doesn't assist in validating what the registrar did.
Say this trust had been set up when Ayana was, sorry, the consent order had been made when Ayana was 17 years of age as opposed to 9. And the registrar is then asked to effect the order in a situation similar to what we've now got. Would that then be different in your view? In other words, are you saying that the 9-year time lag between her age and when she became someone of full age, that is what's making all the difference. Because at the moment, I'm still putting to you that you're making a conceptual argument about the power of the registrar, and that I'm trying, in a sense, to disentangle from a question about length of time might be having some impact. So are you making a conceptual argument irrespective of delay, or are you putting effectively your submissions on the delay?
No, I'm making two arguments. I think I follow what my Lord was asking me now. I am saying, straight off the bat, that as a matter of law, the registrar could not have affected this order.
At any time?
At any time, direct to Ayana. I do make that submission, because that is not the order that she was empowered to make.
And at
That's
that
number
point,
one.
you then have to face that it would seem a rather technical, over-technical position to be taking if there's no delay problem.
In relation to... No, I wouldn't say it's technical, my Lord. Let me explain why. As I understand it, if court orders are made, they are to be complied with as per the order. I know of no situation where that shouldn't arise. And it is not open to any person who has the authority, if you like, to carry out, in this instance, execution of the deed, to do something different to that which the court has ordered. I cannot find any authority that would support that position being taken. My understanding, and we remain firm on this, is that the registrar simply has the power to comply with an order, and that is what she must do, whatever the order may be. And we do take as a separate point, if I understand my Lord Burrows correctly, the delay point. So that is separate, and we will address that.
So you say the registrar's power is purely ministerial?
Yes, they have to comply with the order. The judge has already decided what will happen, how the order or execution of the deed will be made, and that is all the registrar can do, no more, no less. And what I would say, my Lord, particularly with the observation my Lord Burrows has made about pragmatism, I can't see that would constitute an answer to the legal powers of the registrar. And we would say, because this appears to be the first time this has happened in Trinidad and Tobago, that the board should, however it disposes of the appeal, say that the requirement pursuant to the order should be complied with to the letter. But if the board considers that there's some discretion resting in the registrar to identify how that discretion arises to do something other than what is set out in the order. And as I say, absent authority on the point, and with concerns about land fraud and conveyancing and so on in Trinidad, we would remain firm in our view that the registrar should only do that which the order permits.
Bring you back to a point that Lady Rose raised,
Yes.
and that is, we simply don't know, and which combines with the point that I made, and that is that in the statement of claim, your client didn't say, in blunt terms, that the order only permitted a transfer to Ricarda. That is an allegation of fact, it's not an allegation of law, unless I've missed something in the statement of claim. And
Well, my Lord, would it not be a simple matter of saying that the order makes provisions to what is to be done, since there's no dispute about what the order says? How can you say the deed is null, void, and of no effect, unless in fact it's not in compliance with the order? That would be the only basis.
it certainly doesn't help to identify the issues for the parties, and when they come to trial, to establish whether or not the estate of who was the executor of the estate, whether the estate were involved in it.
Well, my Lord, I can answer this. We know that the estate of Ricarda was not involved. We don't know why that was, but we know that they weren't.
Where's the evidence of that?
Well, it would be in the judgment that they would have had someone representing the estate. We know the estate wasn't involved. I don't think there's any dispute about that. There were only two parties to this case, that was Beresford and Ayana. Yeah, I've dealt with that. My Lord,
have you yet found any evidence that this argument was raised at first instance?
Ms. McGibbon is checking this.
We've come back to I don't.
I am not going to sidestep it. I will come back to it.
I want that evidence.
Yes.
Thank you.
My Lord, in relation to the deed, we know that the deed, as I say, was prepared by the respondent's attorney, and the respondent contended that she called upon Beresford to convey the half share to her. So we know that that was something that she was asking for. I've already addressed the board in relation to the lack of information as to how exactly the registrar came to effect this order. But what we know, just by way of background, is that the respondent appeared to have obtained the order in 2009, and this is at the bundle at 197, paragraph 4. And this goes to the separate point of delay. She doesn't immediately act upon it. It does take some time before the transfer takes place. Now, as I say, we've reviewed the authorities from Trinidad and Tobago. We can't find anything in the jurisprudence that suggests this has happened before or in what circumstances. And so this case remains the only one. And I hope to an extent, dealing with my Lord Stephen's point, subject to finding evidence in relation to the point being taken, we say that on this ground alone, because Beresford claimed, as early as his claim form, this is at bundle 6, page 6, paragraph 1, the appellant was asking
what's the electronic?
Page 6.
Page 6.
Page 6, paragraph 1. This is the claim form, my lord.
Yeah.
Paragraph 1. The appellant was seeking the nullification of the deed, and that's the declaration that I've mentioned. And obviously, if the board were to accept the argument that that deed was invalid, then it wouldn't be necessary to deal with any of the arguments in the appeal. But that's as much as I say at the moment in relation to the first topic, which concerns the powers of the registrar. The second argument, now moving to issues of delay, is the limitation period. So this is B, the limitation period. And to the extent that the Court of Appeal claimed that I did not elaborate on what a stale order was, they didn't ask me. My Lord knows that I didn't get a chance to make submissions or engage with the court. And what we say about it is this. There were a number of factors that the court had to take into account, which we say it failed to take into account. The age of the order, the fact that the order was unenforced for 20 years, the advanced age of Beresford, who might have acted quite differently if he knew he would eventually have to part with his property, might have invested elsewhere, and then, of course, the change in subject matter of the order in relation to the buildings on the land. And just the board may already have seen this. What was discovered, in fact, in these proceedings is that the original 1988 order referring to a matrimonial property was not, in fact, on this land. And then, in addition, a third party, now Miss Quashie, who, though blameless, is caught in the crossfire. And we would say that enforcing this order was, in any event, barred by limitation of time.
Yeah, I mean, the argument about change of circumstances is one argument.
Yes.
The question of limitation, you have to get a statutory peg, do you not?
Yes. And I'm going to take the board to that now. We say that this is simply a statutory point. We say it has a direct bearing on whether, in fact, the order was capable of enforcement by the registrar or the respondent in any event. In other words, this is yet another reason why the registrar, even if she had power to do so, should not have effected.
Well, again, you're conflating two completely separate arguments. I mean, you can take us to the statutory case of there being a bar on raising an action, or there being a provision that a judgment ceases to have effect after a certain time. That's one argument.
Yes.
A completely separate argument is what happened during these years and how that should affect.
I accept that, and I wasn't attempting to mix the two, my lord.
Well, let's focus on the statutory provisions first.
Can I take the board, please, to the statutory provision? I'll deal with it separately rather than combine the two. It's page 527 of the record. of the bundle, sorry, and this is the Limitation of Certain Actions Act, Section 3, subsection 2. And if it assists the... I'll give the board various references. The limitation point at 527, just bear with me for one moment. This point was taken in two ways. The first is in the statement of claim, which is page 14, paragraph 18 of the statement of claim, that the order is no longer effective as it is more than 22 years old by that time and in excess of the 12-year time for the period of the validity of court judgments.
Yep.
And it was also the subject of argument, although we only have a note form. This is at page 282 of the record. These are the notes of evidence. And it's at the very bottom of page 282 at line 40. When I refer to lines, my lord, it's on the right-hand side of the page in this version.
Okay.
Now, we know that the respondent argues in its case that partition cannot be subject to a 12-year limitation period, but we say that that isn't right and there's no authority for that. But the way in which we say the statutory provision we've taken the board to operates is that once a judgment has been secured by way of a civil action, there is a time limit upon it before it becomes stale. Now here, Parliament uses the phrase in the section I've referred you to, an action shall not be brought upon any judgment, the word any. And using those words, we say that it is drafted widely to catch any civil judgment, save perhaps matters that might be pure real property matters for the purposes of the Real Property Limitation Act.
Sorry, I want to get that submission clearly. Yes. Any civil judgment except?
Any, except perhaps pure civil matters of land recovery.
Why are you excluding those?
Because the Real Property Limitation Act is a separate piece of legislation that has different time limits. I am going to deal with that as well, but just on limitation now, we deal first with the Limitation of Certain Actions Act, which we say that because this arose in family proceedings under the Matrimonial Proceedings and Property Act, that was the judgment given that eventually led to this order from the High Court in 1986. There is nothing in the Limitation of Certain Actions Act or the Real Property Limitation Act that excludes from its ambit orders made in family proceedings and cannot be read as such. And we would also add to that, my lord, to make good the point that time sensitivity, one would have thought in family proceedings, would be a very clear consideration for limitation, because the longer you leave it, the situation on the ground would change, not least because parties may have moved on in relationships or children grown into adulthood. So what the section makes clear is that where you have a final judgment after a period of 12 years, no action of any kind can be brought upon that judgment. And in this case, we say that that means that the order cannot be enforced, as the registrar seemed to think 20-odd years later.
Nobody's bringing an action.
Well, that's that.
On the judgment.
Yes, that is something that it looks like the High Court judge took into account, because he felt that the mere fact of the deed, dated 2011, was the document from which all of her rights flowed. But what we say is that by seeking enforcement of this order, it would have been caught by the Limitation of Certain Actions Act, because, again, I'm trying to be pragmatic. If you are looking to enforce an order, which is the only thing I think you can categorise the respondent's approach to the registrar as being, however it was done, it would constitute an action to enforce the order.
Well, that strikes me as controversial.
It is, I'm sure, but otherwise, how does one...
I mean, it's a request to the registrar. Section 3.2 is talking about a cause of action being brought against another party, not against the court, not against the registrar.
No, it wasn't. I'm not saying it was brought against the court, my lord. I'm simply saying that the action taken by the respondent was, for all intents and purposes, an attempt to enforce this order, which would have been caught, we say, by Section 3.2.
The word action means a cause of action against against the defendant. Who is the defendant?
Well, even more fundamental than that, look at Section 2.1 of the 1997 Act.
Sorry, my lord is looking...
You haven't...
527.
You haven't produced it, I don't think, have you?
Sorry, my lord, are we looking at something...
Section 2, subsection 1.
No.
The definition of action in the 1997 Act.
I think that's the point that the respondent takes against us.
Well, action means any civil proceedings in a court of law other than those relating to real property. Now, you have the argument that a matrimonial action isn't an action relating to real property, but I don't see how, standing that definition, you can describe approaching the registrar as an action caught by the 1997 Act.
Well, then the reserve position, I appreciate...
Well, do you accept that? I mean, do you concede that?
I would accept that on the wording of the statute, it's difficult to see how it would cover that. But this was an argument made below, my lord, and it may be that it doesn't resonate with the board, but we would maintain it. However, the alternative position we adopt is there was a counterclaim at trial. It was a counterclaim for an order for partition or sale. But that was based on the correctness of the registrar effecting the order, which was the first argument that we've made. And if the order made by the registrar was to be treated as a final judgment or order, which was stale, it being well in excess of 12 years.
Sorry? If the order of the registrar...
If the consent order was in excess of 12 years, then that, we say, would have been caught by the Limitation of Certain Actions Act. And so if I can draw them together in this way, if it would have been out of time for the purposes of an action brought in the courts, how then could the registrar simply make the transfer?
In the same way that the father, Beresford, could have made the transfer whenever he was asked to. If the respondent had gone to him 25 years later, or whatever, or if Ricarda had gone to him and said, will you now please transfer this, and he'd said yes and done it, that would have been a valid fulfillment of the judgment,
yes,
wouldn't it? I mean, he couldn't then say, oh, that was a gratuitous transfer, or the resulting trust for me because there was no reason for me to transfer it. It would have been in satisfaction
on that analysis, my lady, no.
Right. So why is the registrar in a different position from the position of the father when the purpose of the order referring to the registrar is specifically to provide somebody to comply with the order who's not caught up in the emotions of the litigation?
Well, my lord, my lady, in relation to that, I can only rest on the fact that if it is accepted that the order constituted a final judgment for the purposes of the Limitation Act, then it would not have been open to anyone at that stage, including Beresford, unless he wanted to make, as my lady said, a gratuitous transfer to Ayana at that time. I mean, the situation with Beresford making a direct transfer is very different to seeking enforcement of the order. That is something he could have done at any time, I think is what my lady was saying.
Yeah.
And we agree that wouldn't have anything to do with the case or the order. But in relation to how this came about, this was enforcement of the order, and which we say was not something that could have happened after 12 years. But it comes back to, does it not, my lady, whether in fact we are right that the registrar had no power to do this, and now combining it with the Limitation of Certain Actions Act as to whether she couldn't have acted anyway because she would have been out of time to do so, and whether the board would accept that.
Those 2 points
Yes, I mean, you're conflating several arguments. You must keep them separate.
Forgive me, my lord. I'm trying to keep them separate, but this is why I said at the beginning it's really in various stages leading to a final argument. But forgive me, I will.
What you're saying is that once the 12 years had expired, or however long it is, then even though it would have been open to Beresford still to comply with the judgment and effect a transfer to Ricarda or to the respondent, that was not something that was open to the registrar, because when the registrar does it, that amounts to bringing an action to enforce the judgment, even though one wouldn't normally describe a request to Beresford to do that in those terms.
I think I'm answering my lady correctly, and let me be clear as to what I'm saying, keeping it to that one issue. In relation to Beresford, we accept he could have made a transfer at any time. It wouldn't have been dependent on the order. He could have done that, he could transfer the land to Ayana at any time. What we say, though, is that in relation to the process that was adopted here, going to the registrar seeking to enforce the order, that order was no longer enforceable after 12 years of it being made.
No longer enforceable in civil proceedings in a court of law.
Yes.
Because you look quite carefully, what Section 3.2 says, an action shall not be brought upon any judgment after the expiry of 12 years.
Yes.
And Section 2.1 defines an action as any civil proceedings in a court of law other than those relating to real property.
Yes. So we say that no action could have been brought, and I appreciate it's how we make this argument, my lord, and I'm accepting what my lord says about what the section says. There's no issue with that. But that would have prevented anyone from enforcing this judgment. Anyone, including the registrar, who has to act within her powers.
This has nothing to do with the registrar's powers. This is to do with excluding access to the court.
Yes.
But is there anything in the provisions that deal with the registrar that say that the registrar is not entitled to perform that function mentioned in Section 24 after the limitation period is expired?
There's nothing in those express terms, milady, that we have been able to find. But if the general principle is you can't bring an action after 12 years following an order, we are struggling to see how the registrar would have power to effect this order.
Then concentrating on the other part of the definition of an action in Section 2.1 relating to real property.
I'm so sorry, my lord.
I mean, this did relate to real property.
Yes, it did relate to real property. I'm going to deal with that, but I've tried to answer the questions and not, as my Lord Hodge said, mix two issues together in one. In relation to
It's exclusive
how...
real property, isn't it?
Yes, the Real Property Limitation Act deals
but this,
purely to...
But it doesn't say an action means any civil proceedings in a court of law other than those which are governed by the real by another
No,
statute.
it doesn't say that, and that's why I say I have to deal with the Real Property Limitation Act in relation to this. But what the judge below appeared to have done was to have assumed the deed of conveyance was valid, which we have argued that it wasn't, and then did not subject that to scrutiny, where Beresford put in issue the validity of the deed, and I've taken the board to that. The appellant's primary case, my lord, is that because the order on this point, just this point, because the order was over 12 years old, there was no basis for anyone to enforce this order, and you couldn't sidestep the limitation by the registrar simply effecting the order, because otherwise stale orders 30 years, 40 years, 50 years later could then be enforced in situations like this, and we say that would not be in any way satisfactory. But in the alternative, and I am now dealing with the Real Property Limitation Act point, so taking it further, even if the Real Property Limitation Act was the appropriate legislation to deal with limitation, we did take this point both in the courts below, because what it provides is that no land, and this is just for the board's reference, Section 3 of the Real Property Limitation Act provides that no land can be recovered after the expiry of 16 years after the right first accrued. The effect of Section 16 is a perhaps quite familiar disability provision that allows 8 years from after the disability ceased, if they were under a disability during that period. And the effect of Section 22 of the Real Property Limitation Act, again, is the once and for all provision that once your time has expired, that's it. You cannot then bring an action to recover land.
What are the page numbers?
They are not in the statute is not in the record, my lord. But if you look at page 25,
why not?
So sorry.
Sorry, not in the record, but it's in the.
I was going to take, my lord. It's been extracted at 258.
Yes, you give an extract of it. I think.
Yes,
that's right.
It's
yes.
not the actual statute has been word for word set out. It's 258. Which sets out the various provisions at 258 and 259, verbatim. And applying those sections, and again the point was taken below, is that for the purposes of the Real Property Limitation Act, this is yet another indication in legislation that would not have assisted the respondent to enforce as against Beresford, because the 16-year period began to run from 1988, expired in 2004. The respondent turned 18 in 1998, allowing for 8 years, taking us to 2006. But on the 18th of February 2006, the respondent then being aged 26, that 8-year period would have expired, which would have meant that pursuant to Section 22, any right of action that might have accrued against Beresford was extinguished. So even if the Limitation of Certain Actions Act was not applicable here, the Real Property Limitation Act would not have assisted Ayana either.
That's assuming that what she's doing would be classed as recovering any land or rent.
Yes. And that is what we say was the substance of what she was seeking to do. But we move on to another point, which is the same theme about timing limitation, and this is at the board's record at bundle at 529. This is the extract from the civil proceedings rules in Trinidad.
Would you be able to give us a copy of section 2.1, which I don't think is anywhere?
We will do that, and we apologise that wasn't in there, but having...
Could we have also a complete copy sent to us of the Real Property Limitation Act?
We can do both.
Yeah.
What I might do, subject to the board's view, can I simply send through the Limitation of Certain Actions Act and the Real Property Limitation Act, and then you can see it with the bookmarks?
Well, given the importance of these statutes to your submissions, I'm astonished that they haven't been produced to the board.
Oh, I apologise, my lord. It should have been in the bundle. It was not. But I've taken you through to the relevant part, and we will get that to the board.
So at what stage was she entitled to the right to make such entry or distress?
She would have had to gain entry at any time between 1998 to 2006, from the time she attained majority.
Upon what date did her cause of action accrue? When she perfected her title?
Well,
she became the legal owner of the property?
Well, we say that the time would have run from the date of the order. That's what the dates are.
What interest did she have that she could have enforced at that stage?
Well, if she were a person who had an interest of any kind...
What interest did she have at
Well,
that
it
stage?
could only have been an interest as a beneficiary to a trust.
Was there a trust?
Well, according to the Court of Appeal, yes.
As far as you're concerned,
well, we say no, and we've argued against there being a trust.
What was the interest? I'm sorry for pressing you. I really am. What was the interest that she had at the date of the order?
As at the order, she could only have been a future beneficiary under a trust.
Right. Did she have any right to make such entry or distress?
At that stage, time would not have run.
Right. Okay. When did time begin to run?
For the purposes of Ayana, the respondent, it would have been 1998.
And why 1998?
Because that was when she turned 18 and could have made.
And under what right did she have then?
Well, if she were a
No, not if she were. What did she have then?
Well, I'm trying to answer. It may be I'm not answering the way my lord would want me to.
No,
if I can give the answer in this way, if she's a beneficiary under a trust, and that entitled her to obtain the property, that would be when time would run. If that was those were her rights.
And if she wasn't a beneficiary under the trust, upon what date did her cause of action accrue?
Well, if she had, I'm trying to understand my lord's question. If she had if there was no trigger date for the purposes of accrual of the cause of action, then time would not have begun to run. Is that what my lord is asking?
I suppose it could be put in this way, and that is that if you wish to establish a limitation defence, you have to establish when the cause of action accrues.
Yes.
And the judge, as I understood it, considered that it accrued whenever she had the legal title.
That's right.
That's right. Yeah.
That's what he decided.
You would have to displace that, establish that the judge was wrong about that.
Well, my lord, we do have to, and this is why we've taken the board to the various powers of the registrar, etc., to say that this deed was invalid. But, my lord, in relation to the limitation point, I'm trying to keep it to that issue because that's the one I'm dealing with. I've given you the timelines that we say would have applied for the purposes of recovering the property. But it may be, and I see my lord's indication that it may be that the board is not with me on that.
Wanting to test the argument. We're not reaching a view.
No, not at all. But we are resting firmly that if she had an accrued cause of action, that could only have happened when she turned age 18, when she was no longer under a disability.
And the
that
cause
would
of
have
action
been,
then was the Saunders and Vautier entitlement to collapse the trust and call for the half share. Is that what you're saying?
My lord, my lady, in relation, if she had a cause of action against Beresford, I'm trying to answer it in that way, then her time would have run from 1998. But what we have argued, and it may be I'm not making this clear, any right she would have had is actually not in truth against Beresford. It would have been against Ricarda, pursuant to the order that had been made. But dealing specifically with the respondent and how she might have acted in relation to this order, I've invited the board's attention to page 529. I don't know whether I managed to get there yet, but 529 is the civil procedure rule in relation to enforcement of a judgment after 6 years have elapsed. And this is at 529, and it's Rule 47(2).
A writ of execution presumably is somebody going onto land and seizing property, is it?
No, this would be the document issued from the court for the enforcement of the judgment. But what it makes clear, and again, this is still dealing with the topic of limitation, even if you can enforce a judgment, you can't simply fast track and say, I've got an order, I'm going to act upon it. You need permission to do so.
Terribly sorry, I'm just not following it.
529.
529.
This is the extract, Rule 47(2).
47.2. A writ
Yes.
of execution may not be issued without permission.
Yeah.
What is
Where 6 years have elapsed since the judgment was entered, paragraph.
What is a writ of execution?
My Lord, it's the, as I understand it, it's the order that you obtain that enables you to carry out the
I just
judgment.
don't know.
Sorry, my Lord?
I don't know. I don't know what it is. Is it defined somewhere else in the rules?
Well, my Lord, I didn't think there was any dispute about it, but I will. I'll have to come back to the board on that
Okay.
as to exactly.
But if you're relying on the limitation period in the Real Property Limitation Act, you have to fit yourself into one of the subsections of Section 4, which say when the cause of action accrues in various different circumstances. Now, the most likely candidate the courts below seem to think was C, but the judge held that the 1988 consent order was not an instrument within the meaning of Section 4C of that Act. So are you maintaining that that was wrong? Are you relying on 4C as setting the time at which the cause of action accrued, subject to her attaining a majority?
My lady, we do maintain that it was wrong. We took this point in the court below to say that for the judge to treat the order as somehow outside of the Real Property Limitation Act was wrong, and that even applying the Real Property Limitation Act, she would have been out of time. But because of the way in which the Court of Appeal came to deal with it, we've shifted ground for the purposes of the argument before the board, because, and I want to come to this because I know that time is against me.
But what is your position in relation to Section 4?
Well, Lord, we say that she was out of time. We say that the order was caught by the Real Property Limitation Act for the purposes of first accruing an action to recover property, and that as an alternative argument to the Limitation Act, the time would have run from the date of the order, and in Ayana's case, the date when she turned 18. So she couldn't have brought an action in any event, and so it simply supports our position that there was nothing the registrar could have done or should have done in relation to acting on the order.
Could I just say that in relation to your argument on the rules of court 47.2,
Yes.
my starting assumption would be that that has nothing whatever to do with the situation we're dealing with. A writ of execution is not what was being dealt with here. A writ of execution, you go to court to enforce usually a money judgment. You go to court for execution of that. That isn't what was going on here.
It certainly, I accept it wasn't a money judgment, my lord, but ultimately what it came to... I'm sorry.
There's no writ of execution.
Well, my lord, again, this was a point that was taken at trial, and it is one that we've maintained, subject to answering my Lord Stephen's question. She couldn't have simply enforced the order in the way she did. She would have had to at least make an
respect, Mr. Baharlal, let's face the question. If we're not dealing with a writ of execution, why is Rule 47.2 relevant at all?
If the board rejects that a writ of execution is not apt here, then it would be irrelevant. I accept that. But we say that these were various steps and indications in both legislation and procedure that required the respondent to take these steps before she could have enforced judgment, particularly where she was not the transferee. My Lord, I simply give the board this reference. We address this in the court below. It's at E262, paragraph 21. And insofar as, and I'm trying to answer both my Lady Rose's and my Lord Borough's question, in relation to how the judge dealt with this, this is at 292, paragraph 28. He considered that this was a right that the respondent was now entitled to enforce. And so we do say that this was an enforcement. Can I also give the board this reference?
Sorry to bother you, but I just cannot understand how it is that you postulate that there is an earlier cause of action barred by the Real Property Limitation Act without actually telling us when that cause of action accrued and why.
Let me try again, my Lord. In relation to Ayana, the respondent, we say the cause of action accrued in 1988 when she became an adult.
And what was it? And who was it against?
If she had a cause of action at all, it would have been against Ricarda.
But not against Beresford?
Not against Beresford.
Yeah. She now has a cause of action against Beresford on foot of a conveyance made by the registrar. And for the reasons we've given... If that stands, if your argument stands, if your arguments do not succeed, either on limitation in relation to that conveyance or in relation to the fact that the registrar had no jurisdiction to make the conveyance, does that then is that then the first date upon which the cause of action accrues against Beresford?
It would be the same date, that she cannot then go either against Ricarda or Beresford if, in fact, it was appropriate for her to have a cause of action.
That was so. In effect, the real property limitation doesn't add anything to your arguments about the conveyance, because if the 2011 conveyance was outside the powers of the registrar, you win. If it was within the powers of the registrar, both as a matter of construction of Section 24 and also on the basis that it was not outside the 12-year limitation period, then the cause of action accrues against Beresford in 2011.
On that analysis, then yes, but of course we don't accept. We say that any cause of action, if she had one against Beresford, or in fact Ricarda, would have crystallised, first accrued, sorry, in 1998.
Yeah. What would her action against Beresford be?
Well, it could only be, my lord, could it not, if the Court of Appeal is right that the consent order was capable of enforcement, to recover effectively half a share in the land. But that very much depends on whether the board accepts she did by virtue of how that order is structured. My lord, I wanted to move on. I know that, as I say, I've got limited time. Can I deal, please, with the estoppel point, which I'd like to turn to. The point in relation to proprietary estoppel and promissory estoppel was taken at in the courts below, and can I give my lord the references? It's 265, paragraph 31, and 282, 25, lines 25 to 40.
What was the first of those numbers? Sorry, 261.
265, paragraph 31, and then 282 at 25 to 40. Those are the line references on the right-hand side.
Yes.
Now, ultimately, the Court of Appeal took the view that they didn't need to interfere with the judge's findings on this issue, and we say that that was demonstrably wrong. And I know that the board generally does not interfere with concurrent findings of fact, but that is always subject to whether, in fact, the evidence has been evaluated correctly. We say that that didn't happen here. And,
What do you mean? That the evidence has been evaluated correctly?
we say that the evidence was not evaluated correctly
Yes,
in
but
relation to this issue.
what law are you citing to us in respect of the exception to the rule, or the general rule that we don't go behind concurrent findings of fact?
My Lord, can I invite the board to look at, please, the case of Batordier? It's a recent decision of the board, and it can be found at page 559. This is just the relevant paragraph, paragraph 16. I should say, my Lord, I don't doubt the general principle in relation to concurrent findings of fact. But if the board looks at this particular judgment, this is at 559, paragraph 16. In that appeal, the conclusions of the trial judge and the majority of the Court of Appeal were not mere findings of primary fact, but the result of an evaluative exercise, and as a result, the concurrent conclusions do not fall within the principle of Davy and Roy. That is a matter appropriate for consideration by the board. We say that this case falls within that category. And we say that because in the courts below, considerable evidence was given by Beresford, including photographs and receipts of a huge amount of work he had done in relation to the property. And could I give the board these references? It's the statement of claim, pages 11 to 13, the photographs at 29, and the receipts, which are at page 90 to page 171, covering a period from 1997 through to 2012. Now, the board knows that he gave evidence of a resumption of friendly relations with Ricarda and maintained that in cross-examination. The respondent in her evidence was not in a position to disprove that. And if I can give you the evidential references, this is at page 38, paragraphs 7 to 11. Cross-examination 273 at lines 5 to 25. That's for Beresford. And then in relation to the respondent, page 278 at line 5.
Could you just give me the second of those again? I'm sorry.
Sorry.
Page 38 I've got. What was the second one?
273.
Thank you.
Lines 5 to 25. And then in relation to the respondent, 278 at 5.
Yeah.
And then in relation to the promise, she was not in a position to say it hadn't been made. This is at 278 at line 35. And as the board knows, I think it's been accepted that the matrimonial home was torn down and rebuilt. And this is at 278 line 40.
When was that done?
That appears to have happened in 1997 following the Tobago earthquake, my lord.
The rebuilding was in 1998.
The rebuilding started from 1997, was not completed. It carried on for some time. And if the board has, I can give the board the plan. This is at page, actually quite a useful reference is page 44 and 45, where you see the before and after in relation to the property.
These are the plans.
These are the plans. So the plan on the left is 1982, and it doesn't show any buildings on the property, but if you look at page 45, what you can see are the two buildings which are in the middle and straddling two different properties, which were subsequently built by Beresford, and then the rebuilding of the matrimonial house, or what was the matrimonial house, is the one at the front, nearest Miller Street, to the north of the plan.
So the rebuilt house is on the land.
Yeah, there is a rebuilt property, but this is actually the grandmother's property, and that was what was realised in these proceedings. So the shaded area on page 45 is the land with which we are concerned in this case, and the unshaded portion is the land that belongs to Beresford's grandmother.
So the shaded area in page 45
Yes.
contains the grandmother's house and the bulk of the
It contains two separate houses.
and now or formerly Queenie Dillon. Is that the grandmother's house?
That's the grandmother's property, yes.
Yes.
That land boundary which is not shaded, that's the grandmother.
Yes. So the disputed property has,
Is the shaded property.
which is two limited pieces of, two limited parts of the grandmother's house, but nothing else. Is that right?
Yes, the property which has been built overlaps onto the grandmother's property, yes. So if my lord is looking at the hexagonal building, and then the building on the left,
Yes. Was that the hexagon is a building too? What's that?
that I think is a guest house, my lord.
Yes.
And the other building was originally a house which Beresford has extended onto his grandmother's property. And the hexagonal building in particular was covered by the evidence where Beresford built that subsequent to 1997.
And where does Miss Quashie live?
Miss Quashie lives in the new household that we have, which is, the larger household which overlaps the property here.
That's the one that
That's
says
the one on
now
the
or
left.
formerly Queenie Dillon.
Yes, on the left of the hexagonal building, as I understand it.
Yes. But
we don't, the house which is in front, my lord, on Miller Street, which has been rebuilt, I don't want to be too quick to say it's a residence, because that is not the information we have.
But you're saying the non-shaded ground isn't in dispute? It is.
No, the non-shaded ground is not his property. It's his grandmother's property.
So the house next to Miller Street is of no concern to us then? And the bulk of what is now Miss Quashie's house is on land that belongs to her?
The grandmother.
Pardon?
The grandmother.
Well, the grandmother. So where does Miss Quashie live?
In left side property, as I understand it, my lord, which is straddling.
Where does the grandmother live, or is the grandmother
I think the grandmother has now. Yes.
Right.
Well, I mean,
I understand.
So when the grandmother died, what happened? Who owns that unshaded land now?
The unshaded land had belonged to the grandmother. I do not know who owns it now. I can make that inquiry.
Well, no, if it's not relevant, then...
But what I wanted to show is that the shaded area...
So the shaded area, not presumably the street, though?
No, there's a road reserve on the left, my lady, to get access to Miller Street. Is that what my lady is looking at?
No. It may be that it's just the colours have not come on, but the area which is described as 668.3 square metres.
Yes.
That has half the octagon in and a little bit of Queenie Dillon's house in it. That with the path up to the street is the land, half of which was ordered to be conveyed to Ricarda.
That is the property with which we're concerned.
Right.
So Miss
Can I deal with it? Sorry.
Miss Quashie can continue to live in the house identified as now or formerly Queenie Dillon.
Well, that's the difficulty, my lord.
Apart from the fact that just two small parts of it protrude into the land which is subject to these proceedings.
If the property is sold, which is what the order was below, then that would include a part of the property on which there are two buildings.
Yes, but who is going to buy that ground?
Yes.
I mean, it's unsaleable, isn't it?
Well, my lord, one of the arguments I was going to raise, but my lord has asked the question, it creates a difficulty in relation to sale of the property where you've got buildings which straddle two different titles of land. Yeah. And in addition to that, because subdivision is generally regarded as land development, unless you could partition the land, which both parties agreed you couldn't, you would need planning permission to do so. And
I don't think at this stage in the proceedings that we'll be in a position to make new findings of fact about what's happening on the ground. So can I take you back to the concurrent findings of fact rule? Well, and can you make it clear to me, what is it that takes you out of the concurrent
what we say, my lord, is that the evaluative exercise in relation to what Beresford said about the promise that Ricarda would not enforce this order was not properly evaluated. We say that he gave good evidence that this was why he did not make the transfer. And I'm going to give the board the references because I know that the board will want them. This is 317, paragraph 61, and 320, paragraph 67. And I also address this in written submissions 390 and paragraph 81. And could I just say, my lord, that we dealt with this in a lot of detail in the written submissions in the court below, and the board may find those helpful. But what essentially we say went wrong here is the Court of Appeal and the trial judge ought to have looked at the evidential position without the evidence of Beresford. And what one would have been able to immediately identify is that although Ricarda had procured the consent order in the Court of Appeal and was a lady of means and a lady of land ownership, she did not seek to enforce the order to get the deed in 1988. Beresford did not. And having gone through the process of the matrimonial proceedings to secure that order, if in fact she had intended to enforce it, all she needed to do in 1988 was to have told the registrar, he's not done it in 21 days, can you execute the deed? The fact that she didn't called for an explanation. And we say that when you look at the evidence in totality, particularly the inaction of Ricarda and the further actions of the appellant Beresford in relation to the land, developing it and so forth, that demonstrated that something had changed, that the order was not enforced by Ricarda. And the only explanation for that change was the one given by Beresford, which was that Ricarda had made a promise not to enforce the order, which would be consistent with her not having done so.
How can she possibly bind her child?
Well, my lord, we say that as the trustee, or proposed trustee,
Proposed trustee.
Forgive me, I was distracted for a moment, my lord. We say in relation to Ricarda, the position is this. The order was to constitute her as a trustee for Ayana. She not having decided to do so, any remedy that the respondent Ayana would have had would have been as against Ricarda for her failure to constitute the trust. We say that it would not have allowed Ayana to treat Beresford as a trustee, as the Court of Appeal did.
I'm sorry, I do apologise for interrupting, but in order to set up an estoppel, there has to be a clear and unequivocal promise. From whom? That's the question.
Well, we say that
clear and unequivocal promise, which you're trying to set up, is a promise by Ricardo.
Yes.
But it affects Ayana.
Yes.
And it doesn't emanate from her. She knew nothing about it. So there's nothing that binds Ayana.
Well, my lord, we accept that the promise would have to come from someone. We say that that person was Ricarda. That was the evidence that was given below. I can't go behind that now. We say that that promise would have been enforceable by Beresford as against anyone, including Ayana. to set up the estoppel.
At that point,
Well,
I need some authority for that position. Where you have the loss of property rights in relation to a child, that the child itself is bound by a promise given by somebody else and not by her, without even her knowing anything about it.
we would say that in the way in which my lord has just analysed it, she would not be able to do anything in relation to Beresford, in relation to the promise, but if she had a cause of action at all, it would have been as against Ricarda for the value of the interest that should have been constituted under the trust. And, my lord, can I take you, please, to Mountney, which is the only authority we could find that might shed some light on how the order ought to have operated. And it's at page 600.
Are we still on the estoppel point here? Or have we
Yes.
moved? We are.
We are. Sorry. Forgive me, my lord. My Lord Burrows is quite right. I've shifted to my last topic to try to answer my Lord Stephen's question. Can I complete the estoppel point before I deal with that?
Yeah.
May
Can I just say, in relation to what you've so far said on estoppel, I'm not at the moment at all persuaded that you are outside the concurrent findings of fact. You've pointed us to an evaluative exercise. This is not an evaluative exercise. It is simply, did we believe the evidence, or do we think that the evidence supported the view that there was a clear and unequivocal promise? Two courts have said, no, there wasn't. End of story. There's no evaluation such as to fall within the exception, as I understand it.
We say it, well, we submit, my lord, it was an evaluative exercise because when you look at the unequivocal or undisputed evidence, the court did not then go on to consider, well, what is the explanation, and whether then, even if they didn't find Beresford credible,
I think
that explanation is valid.
Talking about mixed questions of law and fact, and that isn't what this is about.
No.
This is simply primary findings of fact.
Well, we say it's an evaluative exercise, and we say that the way in which they dispense with Beresford's evidence, this is at page 433, of the Court of Appeals judgment, paragraph 29, the only basis upon which the judge took against Beresford was his demeanour, which he considered at some points evasive, and that his English was better in his witness statement than it was when he gave evidence. And so he couldn't have had any literacy difficulties. Well, we say that that's not a basis upon which to jettison a person's evidence, that it does relate to an evaluative exercise, and that the proper course is the one I've outlined, to determine, first of all, what are the undisputed facts, the uncontroversial pieces of evidence, and then look for the explanation. The only one
that essentially is simply an assessment of the evidence.
My lord, I make the submission. Yes. I can't take it any further than that.
No, you can't. Okay.
I leave it for the board to consider. Obviously, I've accepted the general principles in relation to concurrent findings of fact, and unless I can bring myself within an exception to that, then I appreciate that the law may be against me. My lord, can I move, please, to the constructive trust point, which was actually the crux of all of this. And I'm sorry it's taken me so long to get there, but in relation to the constructive trust, what we say is that the Court of Appeal, having concluded that Beresford was a constructee for the respondent, is not something for which there is any precedent. And it is not something, we say, that can, as a matter of law, be right, because when one looks at the order, the structure of the order was clear. Beresford to transfer to Ricarda, Ricarda to hold in trust for Ayana. And in the case of Mountney versus Treharne, this is at the board's bundle 600. paragraph 40.
Well, tell us what the case is about.
This is
first.
the Mountney versus Trahan was a case in relation to an order having been made for transfer of all interest in a matrimonial home to a wife. This is, if it assists, it's at page 588, bottom of the page going on to 589. Essentially, in 2000, a district judge in Southend County Court made a property adjustment order in divorce proceedings. On 13th of July 2000, a decree absolute was granted, and on the 14th of July 2000, the husband was adjudicated bankrupt at the same court. There was then an application by the husband's trustee in bankruptcy seeking a declaration, in effect, that the family home, the matrimonial home, vested in the trustee in bankruptcy. And the wife appealed a decision of a High Court judge saying that it did vest in the trustee in bankruptcy, and she eventually was granted permission to appear before the Court of Appeal. And she raised two arguments: that the transfer vested beneficial ownership of the property in her, and equity looks upon done which ought to be done.
There wasn't a transfer, that's the point.
There was, sorry.
Order.
Yes, they failed to find that the failure to find that the transfer vested the beneficial ownership in her was wrong, because that's what the court said. It didn't do that. She says, no, it did. And then the second argument she raised was that the husband's unconscionable behavior could not be used to defeat her claims, and there was a constructive trust by virtue of the order made in her favor over the property. So in somewhat similar terms to the situation between Beresford and Ricarda, where an order had been made, but
That as I read the introductory paragraphs of the Court of Appeal's judgment referring to the judgment of the judge who made the original order in the divorce, which then became the Court of Appeal consent order, what seemed to be decided was that this was sort of Stack and Dowden type situation, that actually the wife, Ricarda, had earned a half share in the beneficial interest of the house through her contributing to the renovation and upkeep, etc., and that she had a half share in the beneficial interest, and the purpose of the order, which became the consent order, was to align the legal title with the recognised beneficial interest. That seems to be different from Mountney, where I don't think it was argued that the wife had a beneficial interest in the property other than the one that was created in order to give her matrimonial relief. So I think it is a slightly different...
Factually, this is why I say there are some similarities, but there are plainly differences.
But
They're certainly not directly.
to rely on Mountney, because the Ricarda had a beneficial interest in the property even before the order was made. The order was dealing with the legal title.
Well, my lady,
See the distinction?
I do see the distinction, but what we say is that in relation to the constructive trust point, which I'm addressing the board on now, Lord Justice Parker dealt with this in the context of the scenario of an order being made but no transfer having been effected. And it's at paragraph 40, page 600. And the way in which he dealt with it was to say that no question of the imposition of a remedial constructive trust arose in that case. Mrs. Mountney's rights under the order cannot have effect beyond which the order itself gives them. And that as far as a constructive trust is concerned, either the order gives her a right binding on the trustee or it doesn't. If it does, there's no need to impose a constructive trust. If it does not, there's no justification for doing so. But the reason we rely on Mountney is really for the general principles that appear to emanate from this, where if there was an equitable interest, that interest vested in Ricarda. And what appears to, in applying the case of McClarkin, which is at paragraph 46 at page 601, and which the Court of Appeal followed in Mountney, they said the moment that this order was made, the wife had an equitable charge on the property which could be enforced at once. Charge, and Lord Justice Chitty, paragraph 47, the charge is given by the order, the deed is only the purpose for carrying out the order. We do invite the board to look, please, at the consideration of the case of Burton versus Burton, which is at page 603, paragraph 56 onward, onto 604, stopping at paragraph 58. And if I can take it shortly, in that case, Justice Butler-Sloss took the view that, and this is at the very top of the page, in my judgment, again, the beneficial interest in that transfer of property does not pass until the consequential documentation has taken effect, and the Act obviously allows for that, dealing with equivalent provisions under the Matrimonial Causes Act. Then on the very next page, page 605, a decision of Lord Justice Parker himself, Beer versus Hyam, top of the page at C, forgive me. In that case, following Burton's case, he said, I held that the order did not itself effect any transfer of the husband's interest in the matrimonial home, rather it required him to take the necessary steps to effect such a transfer in compliance with Section 53 of the Law of Property Act, requirement to be in writing, deed, and so forth. Well, my lord, when you then look at the...
He then says that was wrong.
Yes. He then says, well, I'm wrong about that because following the 1875 case of McClarkin, in fact, it does transfer an equitable interest. But this is the reason I've drawn the board's attention to that is for the value of Lord Justice Law's judgment at the very last page, which is at 609. And we say he puts the matter correctly, where he deals with the equitable principles, remedies, constructive trust, equitable estoppel, and so on. This is at paragraph 85, and says this at 86. Although accepting that they were bound by McClarkin, that being a decision of the Court of Appeal, he said, my difficulty is that I do not see how the evolution of equity can touch the operation of a statutory order as it may touch the operation of a common law rule. The courts, moving a little further on, the courts cannot enlarge or diminish the scope of the statute, save on pain of offence to Parliament's legislative supremacy, nor may they enlarge or diminish the scope of the order made under the statute, save through the process of appeal. And then on the very next page, top of the page, second sentence, if the court is later asked to enforce the order, it must construe the order correctly. And then a little later, but this tripartite process of interpretation, discretionary power, and enforcement is at no point a function of self-standing doctrines of equity. And then a little later at paragraph 87, dealing with McClarkin, certainly with great respect, I cannot see how in McClarkin's case the equitable charge found by the court can, as a matter of construction, be got out of the words of the enabling act. And then a little further, nor can the equitable interest contended for here be got out of the words of section 24(1)A of the Matrimonial Causes Act 75, or those of the property adjustment order made under subsection 6, subsection on 6 July 2000. And then middle of paragraph 88, I have to say that I think it is a line of authority whose correctness is open to question as a matter of principle. And so we would rely on the decisions of Justice Parker in the case of Beer and Hyman and the dicta of Justice Butler Sloss as she then was in Burton, and in particular the judgment, which was not a dissenting judgment, I hasten to add, of Lord Justice Laws, but rather the proper way to construe orders made under the Matrimonial Causes Act in England, the equivalent in this case, of course, being the Matrimonial Proceedings and Property Act, under which the consent order was entered. If that is right, then it wouldn't have transferred any equitable interest, because as an order made under statute, the order was simply an order that required a further step. And if that is right, and I hope answering some of my lords and my ladies' questions, then it would mean that the equitable interest would not have passed.
The decision in the case was that equitable interest did pass on the perfection of the order.
That's what
That's your decision.
Lord Justice Law said, yes, I've got to go along with that. But we do say that it is not binding in Trinidad and Tobago. It's a decision of the Court of Appeal of England, and like all authorities is highly persuasive, but it is not satisfactory. And then drawing it together, my lord, when one looks at what has taken place here, the most that could be said in relation to the order is that if it transferred anything, it only transferred it to Ricarda. It would not have given the respondent as a potential beneficiary under a trust a right of action as against Beresford. It certainly would not have constituted Beresford as a constructive trustee for the respondent, which is what the Court of Appeal found. And so we come back to what was Ayana's course to be taken, and we say that it was not to enforce the order, it was not to bring an action against Beresford, it was, and always was, an action against Ricarda's estate. Can I give my lord these references? We have dealt with...
Before you do so,
Sorry.
the actual order of the court, you said, was made under a... That's the consent order.
That's the
Made
consent
under
order.
a statutory provision. Whereabouts does it say that?
It doesn't say that in the order, my lord, but the genesis, forgive me, the genesis, I'm trying to answer my lord's question. Yeah. The genesis of the proceedings, as the board will see, it's page... page 242. This is the original judgment from the High Court. These were proceedings pursuant to the Matrimonial Proceedings and Property Act. The settlement of property, lump sum, periodical payments, and so on. And so the consent order that was entered was an appeal against that order under that act.
And does this say that she contributed to the purchase of this property?
Ricarda, you mean?
Yes.
Yes, the contributions of Ricarda are noted in the judgment, and that was why the original order made by the High Court was for transfer of the half interest to Ricarda.
But that would be under a trust rather than by... was it a finding that she actually had a beneficial interest by virtue of the contributions she had made, or was it a redistribution of property under a general judicial discretion?
I think it was a redistribution of property, Mel, because of various things that have happened in the short marriage. And she had assisted, for example, with payment of the conveyancing fees and things of that nature for Beresford to obtain the property that he eventually owned.
Where do we see the reasoning on this in this judgment?
If my lord looks at page... So it is at page 251. So it's 250 to 251, but 251 deals with the property, and it's the middle of the page. She found that the applicant, that was Ricarda, expended monies in the conveyance of the matrimonial home to the property, renovations, extensions, furnishings. It would be inequitable for the respondent to be entitled to the whole matrimonial home. So sorry, my Lord Stevens, that's the consideration by the High Court judge on the evidence before her.
So she wasn't redistributing property that belonged to him. She was saying this property belongs to Ricarda.
She was saying that, you know, based on, well, my Lord was asking me the basis. Well, this is the basis.
Thank you very much.
This is the basis. And then she makes the order at the bottom of the page But of course, there was an error, as the board knows, in relation to the matrimonial property, which was not in fact on that land, but here we are. My Lord, I know I've gone over my speaking time, and I do apologise for that, but I hope that I have given answers such as I can to the board's questions.
Well, your speaking time goes on till 12:30, according to my.
Then I'm very grateful for my Lord reminding that. I was having déjà vu from another case where my speaking time was shorter. I'm grateful. My Lord...
you have a full 2 hours.
I'm very grateful.
So there's no need for an apology, and if there are other things you need to say, please say them.
I'm very grateful to my Lord, and can I say that, particularly after what happened in the Court of Appeal, I am extra grateful. My Lord, can I take the board back to Mountney? And it's dealing with the point about, it's really some miscellaneous provisions, forgive me, miscellaneous points. We tried to cover this appeal in the 4 topics that I've raised. However, in terms of the order itself, what seems very clear from the decision of Mountney is that even though they did come to conclude that there was an equitable charge on the property which the wife was entitled to enforce, the consistent theme throughout the authorities that it reviewed from page 600 onward is in fact that the equitable charge on the property could be enforced. And if I could just invite the board's attention to page 601, paragraph 46.
I do again apologise for interrupting, but if Beresford was a constructive trustee, what is the limitation period in relation to a beneficiary enforcing that trust?
If he was a constructive trustee, could I have a moment? Yeah. I wanted to make sure that I wasn't going to say something different to what I thought. In relation to a constructive trust, if that locked and engaged, well, if that arose at the very beginning when the order was made, then there wouldn't be a limitation. I think that is the position. Because...
Following on from that, if, as having looked at the judgment, it appears that it's not that the constructive trust arose from the order was recognising that Ricarda's contributions to the property entitled her to a half share, would you say in those circumstances also there's no particular limitation period on a wife in those circumstances, a cohabitee, enforcing the interest that grows up because of their contributions to paying the mortgage, meeting the outgoings, etc.?
The short answer is no, my lady, but can I try and answer my lady's question? Because this order was made was made in 1998, presumably to reflect the then contributions of the wife, Ricarda. Although the equitable interest may have crystallised at that stage for her upon the making of the order, we do then say, and I'm not trying to dodge the question, I'm trying to demonstrate that in this case, the judgment in the court would have reflected her contributions up until that time. So when it came to enforcing the order, that reflected the contributions she'd made, as I say, at that time, so half the interest. But the problem, we say, is that although she could, as a matter of law, seek to enforce that at any time, she would still have required judicial oversight because of the length of time that had passed and the further contributions that Beresford would independently have made to the property. which would not have been reflected in the original order. Couldn't have been, obviously. And so even then, the proper course of action would have been for Ricarda, in seeking enforcement of that order, after a period or long period of time, not for the registrar to simply make the transfer, but for the matter to be remitted to the court to consider whether there had been any change. What I'm underscoring, my lady, is that there should have been judicial oversight. You couldn't, the longer that you left it, equitable interests can change, especially if Beresford's further investment in the property, which he maintained he had made, would have gone to effect the share that had been ordered many, many years before.
When you speak, well, the property that gave rise ex hypothesi to the equitable interest was the one that doesn't exist anymore. And the piece of ground that's in dispute doesn't have a whole house on it at all. No. It's got part of an octagonal guest house and little chunks of what used to be the grandmother's house.
Yeah. My Lord, in terms of the map, which I've taken the board to, that is, on the face of it, in terms of properties having been built on these two pieces of land, it certainly was a different position to that in 1988. What I'm saying is that because of that, any building on land tends to change its value. That's inevitably the case. Property without a building on it is usually less valuable than a property with a building upon it. It also doesn't take into account other things that Beresford did in relation to the land itself, because having looked at the brief photographs we've got, any, for example, modification to the grade of the land and so on would also have been work that Beresford would have done, and as we understand from the receipts he did do, which would have been reflected, which should have been reflected in his share. But this is why we say that, this is why we say we are in a situation here which is wholly unsatisfactory, where the order is sought to be enforced when so much has changed in a 20-year period. And when the registrar was confronted with this consent order, we've reached a situation now where, at the very least, the registrar should have said, look, I can't effect this order direct to you because that's not what the order provides, but I can remit the matter to the court, which would have then required, because it would have been Beresford was still alive at that stage, Beresford would have been notified and been able to put before the court the various matters in relation to that order. But because of the way in which the litigation progressed, the execution of the deed, and him simply saying, well, look, I'm now meeting this as against not Ricarda but someone else, the most he was able to say is that the deed was not valid because it had not been executed, and that could be the only basis that he could say it, had not been executed in accordance with the order, and then the limitation points that I've already addressed the board upon. The other thing is this, and I've already taken the board to it. Is the order, or terms of the order, so unimportant that it doesn't need to be complied with to the letter? Is it, as my Lord Burroughs said, satisfactory for a registrar confronted with an order to take a pragmatic view? And if they are entitled to take a pragmatic view, how far can that view go? How far can they depart from the order? Because there is a consequence, we say, if the registrar can carry out what the registrar considers to be a pragmatic effect of the order. Where will it end? We are only, of course, dealing with the facts in this case. But if the board says, well, this was perfectly proper for the registrar, then why could she not have gone further? What if, for example, Ayana had had children and for whatever reason was not able to enforce the order herself, but had left everything she owned to her children? So there is a limit, we say, in relation to how the court order could be enforced. And we say that Mountney, to the extent that it does provide help, makes very clear, and it may be I'm answering another part of my Lady Rose's question, what it makes clear is that the person who is named in the order, that is Ricarda, or if she has passed away her estate, could then take steps to enforce the order, but not anyone else. And if Ricarda had sought to enforce the order so late in the day, then it would have been perfectly proper for Beresford to seek to recover expenses for the work he had done that would have enhanced the value of the equitable interest, which didn't exist at the time.
I understand you to be accepting, correct me if I'm wrong, that the Ricardo had, irrespective of the order, a resulting trust, constructive trust, by virtue of the contributions she made to the property, which couldn't be defeated by any limitation period. Is that correct?
Yeah. Well, on the judgment we've just looked at.
Right. And then the order, by the order, she was in effect transferring that beneficial interest to her daughter.
Yes. That would be the...
Yeah. So that was a transfer
consent order
of a beneficial interest. And so that the first stage of the process, Beresford holds the property as a trustee for the benefit of Ricarda. Second stage, by mutual consent, Beresford now holds the property for the benefit of Ayana.
And well, that's...
Consent order.
Sorry, Lord, I interrupted you.
Well, that's the proposition.
Well, that's the submission we say goes too far. We say that there is no difficulty with Ricarda treating Beresford as a constructive trustee, pursuant to the order following Mountney, but it goes one step further and too far to say that Ayana could treat Beresford as a constructive trustee for her interest.
But Mountney isn't based upon contributions having been made.
No.
Mountney is based upon an analysis of the legislation, the applicable legislation. This is more fundamental. This is contributions have been made. Beresford is a constructive trustee, and he agrees that he will now, in effect, transfer the benefit of that to his daughter.
Well, in terms of the consent order, my Lord, I don't disagree. That is the effect of the consent order had it been carried out. Sorry, I'm just dealing with one matter in relation to... I'm grateful to Miss McGibbon. It may be worthwhile just, when the board comes to look at the judgment, if it is material for the purposes of disposing of the appeal, this is the judgment of Justice Permanent. Yeah, I don't think I can It may be worthwhile just looking at page 251 again, my lord, in relation to the judgment from the High Court.
251.
This is 251. This is the judgment, the original judgment that gave Ricarda a half share in the property.
Yes.
And I'm just looking at the findings that the judge made in the middle of the page, expending monies in the conveyance of the home, renovations, extensions, furnishing of the matrimonial home. Of course, that was the home that was on somebody else's property, which we now know but did not know at the time. And so that may have some bearing on how much, in my Lord Stephen's analysis, how much value can be placed on that when we now know that was not in fact on the land which is the subject of these proceedings.
So her contribution to the matrimonial home was on different, related to a property on different land.
Yes.
But
and then she then made an order to reflect that in relation to the home and assumed it was on the land with which is the subject of these proceedings. So just in the analysis, the factual analysis of contribution and so forth, that may be relevant, certainly, to the share that she adjudged was appropriate, and that we would add to that, my lord, the further work that Beresford would have done over the 20-year period since the order was made.
yes, but the oddity is she got no share whatever of the matrimonial home that she improved. She got a share of land which is largely unbuilt on, except for Beresford's guest house, half of which is on that land,
yeah,
and little bits of the house that used to belong to the grandmother.
Well, she actually got the order that was made. Sorry, maybe my lord is making this point to me, but she got a half share in the matrimonial home. That was the order made in addition to the land on those 2 pages. Sorry, I'm just looking at the order, which is at the bottom of page 251 going on to 252.
But the only share that could be given to her was of land which Beresford owned. The land that the grandmother owned wasn't.
No, that was not part of the order. Yeah, Milady.
She gave an order about in respect to the matrimonial home, while the consent order was simply in relation to matrimonial property described in the particular deed, together with the building and appurtenances standing thereon, and you're saying there were none.
No, because a mistake had been made. What they were looking at was the building which was on the grandmother's land, which they assumed was all on the piece of land which was the subject of the deed.
Yes, but if you look at over the page at 252, little b, 1/2 share, so she gets 1/2 share in the matrimonial home with the drawing room and the bathroom and the kitchen. She also gets 1/2 share in the lot of land on which the matrimonial home stands. Now that was the error, in fact.
Yes.
But it was still thought that her contribution entitled her to a half share of, I don't know whether that deed reference is of the unshaded or the shaded land.
It's the shaded land. It is the correct
land, right.
land owned by Beresford.
Right.
They had that deed at the time, just it didn't appear they had a plan at the time. But, my lady, what I would say to that is that had the error been known at the time, the order might have been different, but it was not known at the time. And then we have to then factor in, as I've mentioned to the board already, the situation that changed subsequent to the 1988 order, because it means then that anything Beresford did in terms of furthering contribution or enhancing the value of the property counts for nothing.
Well, enhancing the value of the shaded land?
Of that property. If any improvement, whether it's levelling the land or putting down foundations for the purposes of a building, any improvement to the property is not reflected in the order in 1988. Well, for obvious reasons. It's, long before.
Yes.
My Lord, I'm almost hesitant to ask, does the board have any questions for me? Because I think I've come to the end of my submissions.
Thank you very much.
There's only one point.
Of course.
Just to gently remind you about whether the argument was raised at first instance.
Yes.
And
Could I am going to, we haven't been able to find it yet, but I'm going to check now. So whether the argument in relation to the deed was raised at first instance.
right. Whether the argument was raised that you couldn't transfer, the registrar couldn't transfer to Ayana, could only transfer to Ricarda.
I'm going to double check, but can I say two things to answer my Lord Stephen's question? It was, I think, raised in the court below. That's the Court of Appeal.
We know that.
In relation to the High Court, it appears the limit of what was mentioned was that the deed was null and void, and I'm going to double check.
Well, that's a legal assertion which could apply to anything.
A range of matters.
Yes.
Yeah. But the only basis, I mean, I underscore this, the only basis one could make that argument is if the registrar had acted in excess of the power she had to make the order.
She could also make it on the basis that it was outside the limitation period.
But that is the only the argument he made about the deed being invalid was grounded on that understanding. And
I think we need to,
of course,
I'm
going to double check that that I think is the position, and if it assists the, I can give the board these references now. It's the statement of claim. Well, rather than do this on my feet, can I just have a look at it? Because I want to be precise about the page and paragraph numbers I'm going to give.
Yes,
can I assist the board further other than that?
Yes, I'd be interested to know what was argued, whatever may have been the statement of claim.
What was argued in court?
In pretty general terms, but what was argued before the judge?
The High Court, yep.
Yes.
I'll look at that now.
Thank you very much. Well, the board will adjourn to consider where we are and return thereafter.
My Lord, you asked me the question in relation to whether the point in relation to the registrar's powers had been raised in the High Court. I cannot find any express reference to that statutory provision. And I've looked both at the claim form, as well as the submissions that were made.
You mean to section 24?
Yes. I think that was my Lord Stevens was asking for clarity on that.
Thank you.
Could I, however, give the board the references that we say bear on it? It's page 614.
614.
6, page 14, page 17, and page 262, all of which go to the issue of the validity of the deed, but there is no express reference to that section.
There's no express reference to it being the wrong person. Okay.
It's not that's not been put in terms at all, and the closest I can come to it is, as I've shown the board, the declaration and the submission that the deed was null and void. Unless I can assist the board further.
Thank you.
My Lord, can I say that those extra statutory material is coming to the board? Would it be of assistance if I extract the sections as well as give the whole act?
I think you just give us the act if that's what you've copied. That will be absolutely fine.
Thank you.
Thank you very much. Mr. Manwan, good afternoon. The board does not need to hear you on the question of estoppel, but we would like to hear you on the other matters. We can't hear you.
I'm sorry, my lord, the microphone was muted. My lord, I will start with the limitation point. Lord, I am making the distinction between the enforcement of a judgment and the right to sue on a judgment. The Limitation Act clearly states that no action can be brought under judgment after 12 years. What that means is that after 12 years, you cannot use a judgment as the basis of filing any fresh action. What the Act does not do, it does not put any limitation as the right to issue any execution under that judgment. In other words, the right to sue on a judgment is a substantive right, and the right to issue the execution under that judgment is a procedural right or a remedy. The first is barred, the second is not barred. So on the assumption that the signing of the deed by the registrar is in fact some form of execution, which we're saying it is not barred. Now, sorry. So that is my point with respect to the limitation point there. There were two other points raised with respect to limitation, which was the partition ordinance. Now, the Court of Appeal dealt with this at paragraphs 38 to 39 of their decision. That was at page 436 and 437 of the record.
436.
The 437. The issue that dealt with is whether the partition is statute barred. Now, partition is not any type of action for recovery of any land. It is simply an action where you have more than one owners to physically divide the land or to sell it in lieu of that partition. There is no limitation anywhere in that act with respect to when you can do that. All that is required is that you have an interest in the property. With respect to the Real Property Limitation Act, there is also no limitation there that applies to this matter. The act of the registrar signed in the deed is not sorry, I'm a bit on. Right, sorry, I'm dealing with the limitation with respect to the partition. What the court has found is that the right to bring any action for partition starts with the 2011 deed. So notwithstanding that my first submission is that there is no time bar with respect to bringing the partition, even if there was, that time started in 2011. And if that time was 12 years, as my friend said, we would have been within that time frame.
What is your position as to whether there is a 12-year time bar on raising actions of the nature that we're concerned with here? Do you accept that the Limitation of Certain Actions Act could apply, or are you treating what we're dealing with here as an action relating to real property?
Well, in my submission at paragraph 7, I stated that Limitation of Certain Action Acts as defined, action in that act means any civil proceedings in a court of law other than those relating to real property. So in any event, it would not relate to this matter here, this being a matter in real property. Now, there is one point. The act that is before the court is an act that came into force in 1997. This order was made in 1988. So it is possible that this act may not be the applicable act, but the act prior to this.
Well, does the Act say anywhere how it applies to existing judgments?
No, it did not. But if the time started to run from a period, they started to run prior to the act coming into force, I take it that that period would be governed by the then existing act and not the new act. Now, my friend referred to the Real Property Limitation Act with respect to Section 3, that you're limited.
Yes, just dealing with your point. What the transitional provision in the Limitation of Certain Actions Act 1997 says the Act doesn't apply to any action brought upon a right of action which accrued before the commencement of the Act. That's Section 20.
Yes, that will be correct. So if there was any cause of action that existed prior to that Act would have been covered by the prior Act and not the 1997 Act.
And what was the prior act?
The prior Act was the Limitation of Personal Actions. It was an ordinance here. Yeah. It was a Limitation of Personal Actions Ordinance. It was a very old Act, ordinance.
Which is repealed by this 1997 Act.
Yes, it was repealed.
But we don't know whether that contained a provision similar to Section 3, subsection 2.
I think it does.
Well, perhaps we should ask that a copy of the relevant ordinance is made available.
Yes, we'll do so, my lord.
Thank you.
There's a slight difference. In the 97 Act, the Section 3.2 reads, an action shall not be brought upon any judgment after the expiration of 12 years from the final judgment. That's the basic section my friend relies on. In the prior Act, the Limitation of Personal Actions Act, it goes, Section 3, all actions, suits, or proceedings brought to recover any sum of money secured by any mortgage, judgment, or speciality, or charged upon or payable out of and being a lien upon any land or rent.
Where are you reading from? I'm so sorry.
I'm reading from the Limitation of Personal Actions Ordinance.
I see.
This is chapter 5, number 6. So it's a previous law that governed limitation. And this is section 3.
Could you read it again, please?
Yes, my lord. All actions, suits, or proceedings brought to recover any sum of money secured by any mortgage, judgment, or speciality, or charged upon or payable out of and being a lien upon any land or rent, or for the recovery of any dutal claims, or any legacy or share, or of any inheritance, and all actions of account between partners in land or commerce, or between co-heirs, or against any executor, guardian, trustee, curator, administrator, or agent, shall and may be brought at any time within 12 years next, after a present right to receive or have the same shall have accrued to some person capable of giving a discharge for or release of the same, and not after 12 years, unless in the meantime some part of the principal money or some interest thereon shall have been paid.
Well, that doesn't seem to deal with what 3.2 deals with, which is about actions brought on a judgment. But is there an equivalent of that earlier ordinance to what is now in 3 subsection 2 of the Limitation of Certain Actions Act? Doesn't seem to be what you read out.
It does not seem so directly. Lady, to answer your question, it does not seem so. This is the only section that deals or mentions judgment. And it seemed to be limited to all actions, suits, or proceedings brought to recover any sum of money secured by any mortgage, judgment, or speciality. So it seems to be limited to money being secured by the judgment.
Well, would that, here in London it is now 1 o'clock, would that be a suitable point to adjourn? And could I ask those instructing you to email to the court the relevant provisions of this ordinance so that we can look at it in paper form after lunch?
I will do so, my lord.
Thank you. The board will now adjourn.